Hi, my name is Moumita Rahman, and I am the immigration attorney here to help you navigate this complex world of immigration. Today, I'm going to discuss some extremely important, great news for all seekers of green cards here in the US, and also those who are seeking to get an immigrant visa from overseas. And today's video is about the public charge rule and the injunction that has been put in place specifically prohibiting USCIS from denying applications because of this new public charge rule that came into effect in February 24th of 2020 this year. But before I go any further, I'd like to introduce myself. I am an immigration lawyer based in New York, and I serve clients all over the US. I have been working as an immigration lawyer for almost 10 years. If this is your first time watching me, please go ahead and subscribe to my channel. I really appreciate all of your support. And please make sure you hit that notification bell so that you can be notified every single time that I put out a video. Trust me, you don't want to miss a thing these days because immigration law is changing and there is something new almost every single day. And I do my best to bring you the most relevant, up-to-date information. So, what is the public charge rule? If you don't know what the public charge rule is, all that you really need to know is that it is essentially a wealth test. This rule has been designed by this current administration in order to keep people from getting a green card. And what it really does is it is designed to basically measure how much money you have, how much education you have, whether your credit history is good, whether you can speak fluent English, whether you went to college, all sorts of things that the government has never looked at before. And the purpose of this new public charge rule is basically to assess whether a person who is about to get a green card is likely to become reliant on government benefits. Now, in the past, if you were applying for a green card, all that you had to do was request that your sponsor submit a tax return and proof of income to show that their income is at a certain level and that it is enough to keep you from becoming a public charge. But now what the government is doing with this new rule is to look even more deeply at things that it had never looked at before. And also the government released a new form called the Form I-944. This form is a very burdensome form. This came into effect this year on February 24th, 2020. So any person applying for a green card was required to submit this I-944 unless they fit into an exception. I'm not going to go into all of those little details right now, but you can go ahead and watch some of my earlier videos where I do go into the public charge rule in depth. But you don't need to worry about that right now. The Supreme Court has held that because of this COVID-19 pandemic, the government should not be allowed to deny applications based on this new public charge rule, and that the government should go back to its old definition of public charge, which basically just requires the submission of that tax return and proof of income from a person's sponsor. This is really great news because people have been afraid to get COVID-19 testing and COVID-19 treatment, especially if they were without insurance, because they were afraid that they would be denied the chance to get a green card. So let's talk about what this means in practical terms. If you are filing for a green card right now, do you have to submit the Form I-944? This is actually a little bit of a tricky question. First of all, USCIS has said on its website that from July 28th onwards, any adjustment of status applications received that do not include the I-944 form will not be rejected. Also, if you do actually include the I-944 form, you will not be rejected either. However, in my experience, or if you may already know this because you have filed applications in the past, the USCIS offices and lockbox location are kind of notorious for rejecting applications for certain things. And one thing that we have seen is that persons' applications have been being returned as rejected for even missing the I-944 form, even where it was included. So my recommendation is that if you have already prepared the I-944 form, go ahead and submit it. One of the reasons why I also believe this is because the instructions on the I-485 still ask the question as to whether you are exempt from this provision or whether you are not. Moreover, the instructions to the I-485 still go ahead and say that you must submit an I-944 form if you are required to. What should you do with these two conflicting pieces of information? The form instructions say that you need to include it, but the government's website says that you don't need to include it. Well, I think it's always better to be safe than sorry. If you have already prepared this form, go ahead and submit it. But if you are having problems putting it together and gathering all the evidence, then go ahead and submit it with a printout of the government's website saying that it is not required. But also keep in mind that this injunction that has been placed is only temporary. The judge specifically said that this injunction should remain in place as long as the COVID-19 national emergency continues. And while we all hope that this emergency with our nation will be over soon and that we will all get better and back on our feet, who knows how long that will actually take. So keep this in mind. Good luck. If you need my assistance in filing your case, please give us a call at 212-248-7907. Adjustment of status applications are something that is so crucial to this country because it helps to keep families together and stay in the US. I hope to see you next week. And again, please share this video with anyone you think who might need to see it. See you next week. This video is for informational purposes only and does not constitute legal advice. For proper legal advice on your case, please call us to set up a consultation.